Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Margarita Grup.
Welcome to Hull on Estates. You're listening to episode number 671. Today, we are going to be discussing the Queen of Soul, Aretha Franklin. She died a number of years ago, and her estate and our fight over her estate has been in the news of late and has been resolved in the United States. So we wanted to chat about it and some of the issues that arose and how they relate to Ontario as well. So, Margarita, do you want to tell us about the Queen of Soul?
Yeah, absolutely. So she died in 2018. And at first, it was assumed that she died intestate, so no will was discovered initially immediately after death, in which case the assumption was that intestate state law would apply to her estate. But then a few months later, two documents were discovered in her house. One was a handwritten will from 2010 that was found in a locked cabinet, and another one was a will from 2014, also handwritten, discovered under her couch cushions. So that kind of initiated a legal battle between her children. I think she has 4 sons, on the validity of the wills. So overall, both wills kind of divided the estate between the children. There were some variations. There was a difference in the, I believe, in the co-executors that she appointed in the 2010 will and the 2014 will. And there was also a criteria in the 2010 will where she said that 2 of her sons have to complete some sort of certificate or receive some kind of diploma in order to benefit from her estate. And then the latter will was changed slightly and gave her main residence to one of her sons. So unlike in Ontario, they headed into jury trial to determine the validity of the 2014 will. And I believe it was earlier last week that the jury decided that it was actually the 2014 will that is the valid one, and they should apply to her estate.
Yeah, so there's a lot of lessons to be learned from this. Aretha Franklin had millions of dollars. She was a famous celebrity. She was not young when she passed away. She had plenty of time to get her affairs in order. And this was the state that she left her children in. No will to be found. A holograph will in a locked drawer with other, to be fair, it was in a locked drawer with other documents, and perhaps that's where she kept her important documents. Both wills were discovered when one of the daughters, who was the estate trustee or intending to be the estate trustee, was looking for papers. So, in fairness to Ms. Franklin, she did keep one will with papers, but the other one was in a spiral notebook under her couch, or under the cushion of her couch, which is not where I recommend you leave your last will and testament. It's not the first place people look when you pass away. So let's talk about holograph wills to start. All right. What can you tell us about holograph wills? Let's talk about that one for a minute. In Ontario, what are the requirements?
So generally, there's nothing wrong with having a holograph will. It's just that you would have to make sure that it complies with the formal requirements, which is that it has to be fully handwritten by the testator. It has to be dated, and the signature has to be at the very end. So you don't want to sign the document in the middle, at the beginning of it, and it sort of has to clearly state that these are the testator's final wishes and intentions. So these basically are main requirements. Mm-hmm.
Yeah. So of course, everything now that we talk about has to be couched in this cloud of, well, we've got to also have a substantial compliance regime, right? So, there are formal requirements. They're formal, but less formal in that, if they are not complied with, it does not necessarily mean that it is not a valid will anymore. That if a court determines that this did represent a full and final testamentary intention, a court can declare it to be a valid will. Those cases are starting to come in now in Ontario as more time has passed since the legislation was changed. But yes, it has to be in your own handwriting, wholly in your handwriting, signed by you, dated, and it has to represent your final testamentary wish. So that's holograph wills. All right, let's talk about planning. All right. Just because you have a will, that's sort of not the end of your responsibilities as a testator if you want things to go smoothly. I mean, it's generally my recommendation that you tell your estate trustees, hey, listen, you're going to be my estate trustee when I pass away. Do you mind doing it? Do you want the job? Can I count on you to do it? Here's where I'm leaving my will. My will I'm leaving with my lawyer. Oh, I'm leaving it in a filing cabinet in my office downtown. I'm leaving it under the cushion of my couch, if that's where you want to leave it, as long as someone can find it. So, it's making a will is great. Having a will that no one can find doesn't do anybody any good. And, we see from this, this case, this Aretha Franklin's, that it caused a lot of problem between the kids, because no one knew what mom wanted. And so everyone's fighting over, well, you're trying to do this something mom didn't want. And we see that a lot in the files that we see, in the cases that we see. Listen, when the testator isn't there to speak and tell everyone what they intended, everyone is suspicious of the other, trying to get away with something, trying to do something that was not intended. And it creates a lot of ill will. And, in the article that I was reading, some of the children were saying, well, we hope this is not going to affect the relationship moving forward, but it's hard not to. The last thing I want to talk about is this jury trial issue, because this jury trial thing I find fascinating. In the years that I've been doing it, I've never seen a jury trial in respect of a will challenge. I've never heard of a jury trial in respect of a will challenge. All of the order giving directions that we do that are being converted into an action always say that the proceeding will be tried by a judge without a jury. And that sort of got me thinking, well, could we have a jury trial in Ontario in respect of a will challenge? So I don't necessarily have definitive answers, but I have some information. All right. So Section 8 of the Estates Act, Section 8, Sub 1 says the court may cause any question of fact arising in a proceeding to be tried by a jury. All right. So that does not completely shut the door on a jury trial in a will challenge. Certainly, there are some issues governed by the Estates Act that can have a jury trial in respect of findings of fact. If we go to the broader legislation in the Courts of Justice Act, Section 108, it talks about jury trials in respect of issues of fact or damages to be assessed. But there are some exceptions. Not every civil case can have a jury trial. So, for example, partition and sale of real property, you cannot have a jury. The execution of issues in respect of the execution of a trust, you cannot have a jury. Rectification, setting aside or cancellation of a deed or other written instrument, you cannot have a jury. Declaratory relief, you cannot have a jury. Equitable relief, you cannot have a jury. So there are a lot of carve-outs, and a lot of them that seem to fit within the estates and trust regime. Some of the cases I've read, where there were requests to have a jury trial, at least one of them, the court found that the seeking relief in terms of the declaration of a validity or invalidity of a will is really declaratory relief. And Section 108 of the Courts of Justice Act says no jury. And so the court in that case declined to exercise its discretion to have a jury trial. Because if we go back, Section 8 of the Estates Act says the court may cause any question of fact arising and proceed to be tried by jury. So you're not automatically entitled to a jury trial, even if it doesn't fit with one of the exceptions. It is the court's discretion to allow a jury trial. And so the court, at least in some of the cases I've read, are not exercising their discretion. Interesting. It's not something that I thought about, but at least for now, I don't think that we're going to see any jury trials on a will challenge.
Yeah.
Whether or
Yeah.
not we see one in a work claim, I don't know. That's a different question. We'd have to go down that rabbit hole. But I think that sort of concludes our podcast for today. Until next time, I want to thank you for listening. I'm Jonathon Kappy.
And I'm Margarita Grup.
Should you have any questions, please email us at info@hollandhull.com or contact us through the contact page of our website. Have a great day.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.